Hello, everybody, and welcome to the Scanner Monkey TV show. It's Thursday night. Time for another episode. This week's show is hosted by both Scanner Monkey and we have Andy Slammons from Alibaba to Amazon, as well as Slamazon, co-hosting with us. And then we have our awesome guest, Rick Walker, who is a trademark and IP attorney, and he's going to tell us what that means in a few minutes. He's great. Rick is very involved in the startup community. He's a big fan of startups here in Atlanta, and so he certainly wants you to do smart things, but is not just expecting you to come in and pay $10,000 for every idea that you have, kind of thing. So, but Rick is a good friend of my husband's, and I've also known him for a long time, and he's just a super helpful, awesome person, and he generously agreed to come on the show tonight and answer our really crazy, nitpicky questions. And now, I say that he's here to answer those questions, and I'm going to preface that a little bit by saying that he is an attorney, and there are certain things he's not allowed to, like he can't give legal advice on our show because we're not paying him. So, and neither are you.
I was about to ask that. Are we getting like a $500 an hour bill here? What's
You get what you pay for, so wait till you hear it.
A lot of yes and no answers. We're paying for this.
Most of them are "it depends." Or
it depends, right?
What's that?
So he's obviously going to do his best to be helpful, but there may be some things where he has to say that he can't answer the question.
Some things he'll have to say, make an appointment.
Make an appointment.
Can you do some of this stuff over the phone there, Rick, or is this mostly a face-to-face thing?
A lot of it by phone. Most of my clients are virtual.
Good.
Yeah, exactly. Okay, and then for those of you in the audience, we have the chat, which if you click on that, opens a separate chat window, and you can chat with each other in the audience, and you can chat with us. And then you can also, in the Q&A section, that's a place for you to ask questions for Rick or one of us. I don't know why you'd want to ask us a question. Rick's here, but those will be there. And then we will get to those as we can, but they won't disappear sort of like the chat flies right by. All right. So are we ready for the should we dig right into the presentation? Okay, hold on.
Yeah, I'm ready. Hey, while you're bringing up the presentation, Cordelia, how about if I give you my required disclaimer?
Please do.
It starts out, blah, 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 blah. But I really do need to say this at the request of my partners and my insurance company. So here it is. I'll say it really fast. But I guy did a FedEx commercial about 10 years ago, right? This presentation is being given by me for informational purposes only and does not constitute legal advice. It is not intended to create, and the receipt of it does not constitute a lawyer-client relationship. You should not act upon this information without seeking advice from professional advisors. Now let me translate that into real words. I am not your lawyer. You are not my client. To do so, we've got to get together. So we'd have to have an engagement letter and a retainer. But I'm happy to fill you in on just a lot of general concepts that I think you're going to find very helpful. I've been down this path myself as an entrepreneur, and I'm not crazy about paying lawyers or other professionals myself. So I'm going to try to pass some of that along, and I'm going to tell you a few war stories that I've actually lived through myself.
Awesome. All right, let me start the presentation here. Okay. All right, do you guys see the slideshow?
Yep.
Yes, and we've made sure nobody else can screen share, right?
Yeah, let me do that. You're right. Yep. Let me.
Just in case somebody wants to jump in with some of their own.
Thank you for reminding me to do that. Okay, now nobody else can screen share. Okay, so somebody asked me about how to get the chat window. For some reason, some people have trouble seeing the chat. And unfortunately, if you can't figure it out from what we said, you're going to have to contact Zoom help because there's no more support I can give live during the show. But if you have a question for Rick, put it in the Q&A. And you can also PM Jay, Andy, or myself in Facebook, and we will try to get to those as well. But I can't do tech support during the show, unfortunately. So it turns out I can only do so many things at once. Okay, so here we go, Rick. Just do a little hand thing, and I'll fast forward the presentation.
Okay, you can go to the next one. This is the general concept for tonight. We're not going to talk about patents, which fall within that big umbrella of intellectual property. It's sort of a snooty sounding word, I guess, intellectual property, patents, trademarks, copyrights, trade secrets, and all the related agreements. We're going to focus tonight on just trademarks and copyrights. And there are three things that I'm hoping will be a takeaway for you tonight. One is I want you to appreciate the difference between trademarks and copyrights, and that they are different. And I'll try to give you some examples of why they are different so you know what it is you need to protect on your own materials, and what it is when you see something that somebody else has offered in the alleged public market. And one of the cautions tonight is there's probably no such thing as public domain on the internet. You got to be really careful. Second, I want you to appreciate the difference with both trademarks and copyrights of the concept of registrability, that is registering a trademark or copyright, and the concept of infringement. Two are totally different. You can get a registered trademark and still be guilty of infringing somebody else's trademark. So I'll help you with that. And then I want to help you, one, appreciate some of the risks, but more importantly, how to lessen those and how to be street smart in working your way through a business that you want to be profitable. So,
okay.
Next slide. You'll see on this slide, I've got something on either side of it. There's a TM and an SM. A TM stands for trademark. SM stands for service mark. TM
stand for scanner monkey?
Hey, it could. Uh-oh, I might be infringing there.
You're infringing on our trademark. Give me $1 million.
Okay. Trademark, TM, that's the common law symbol that's used, and I tell my clients to use that from the very first time they start to use their trademark. It's free, okay? You don't have to register it, but it really resides, from a legal standpoint, under state law. So you're subject to 50 different states, 50 different laws. It's a common law trademark. Historically, it used to be based on footprint or geography. So if you were Joe's Barber Shop in a suburb of Atlanta, your footprint would probably be around that suburb and where word has spread or where you've sent out advertising materials. It's a little different world today with the internet, but there's still some tests that are used to find out what your footprint is. Service mark is pretty much the same thing as SM is pretty much the same as TM. To me, it just shows that you probably talk to a lawyer and he says, hey, use SM instead of TM. It's still common law, but it'll show you talk to a lawyer. So maybe you're a little better equipped to sue people. Okay, right in the very middle there, Circle R. That's the Circle R registration you get from the U.S. Patent and Trademark Office. That's the federal government agency that examines and registers federal trademarks. So you should be proud if you get one of those. And a lot of people don't, yeah. Correct. A lot of people don't. It's not an automatic procedure. It is an application. And now look at that. There is a genuine U.S. trademark. If you can hold it down hold it up a little higher, and you can see the beautiful gold seal on that. Very impressive document.
Thank you.
Excellent. And you can probably
I'm proud of it. I'm going to have it framed one of these days.
You can tell people, Jay, that was not automatic. I mean, you filed it day one. They acknowledged it probably maybe the same day if you did it electronically, but you don't even hear back usually for 3 or 4 months.
It took me 5 months.
Yeah, and then it's usually a rejection that you try not to take personally. You got yours through without?
I got mine through, and you know, even though there's a little bit of resemblance with our monkey and the Family Guy monkey, not a problem.
Good, good.
So we're covered.
Yeah, it probably helped with the way you described your category of goods or services. So I'll get into that a little bit.
Okay.
At the bottom of this PowerPoint slide are just some typical trademarks. So next slide, Cordelia. Now let me give you a little bit of some conceptual things to think about here. A trademark. It's a word, it's a symbol, it can be a sound. It's used to identify a source of goods. Now think of it as a brand identifier. A good example might be McDonald's. If you go to McDonald's in Atlanta and you order a quarter pounder, you're hoping, and McDonald's is hoping, that it's going to taste exactly the same in Seattle. So it's sort of a handle or a way that you can expect that same quality of goods from that same source of goods. So the trademark office allows you to say, okay, I want to register quarter pounder and I want to use it on food products, namely hamburgers. And if you get that, you start to use it, it becomes more and more famous. That's how trademarks work. It's the use of a brand identifier used in interstate commerce. The more you use it, the better it gets. You also have to protect it. So if somebody out there is starting to use the term quarter pounder, you pretty much have to send them a cease and desist letter. Otherwise, you can lose it. And I'll give you some examples of that. Things like the word cellophane or escalator. Those have gone into what's called the public domain because the users did not pretty much snap the whip on people who were using their term generically. Trademarks are good in that they can pretty much last forever. You have to once you get one, and Jay, maybe you're not there yet, but between the 5th and 6th year, you're going to have to file a declaration of use, swearing that you are continuing to use this trademark and it's still used in connection with your goods or services. And at that time, there's something else you can file at the same time, a declaration for incontestability. Okay, so after those 5 years, it goes for another 5. So after about 10 years, you can have it renewed. And after that, you can just keep renewing it. So
do you have to do it like every 5 or 10 years, or does it just go on forever?
You pretty much have to renew it every 10 years. But after the first 5 years, you have to file a certificate of continued use. There are some attorneys that like sort of putting in their own certificate of continued use in some way, but it's not necessary. A lot of foreign countries have declarations of use that they just recommend filing.
Hey, Rick, can I jump in real quick? Just as a cautionary tale for people that have received their first trademark, something that I received, I'd say at least 1 or 2 letters a week from different organizations that claimed that they were like an international catalog of trademarks. Yeah. This is actually one of the letters that I got, and it just said, we can go ahead and catalog your trademark with this worldwide organization, and it'll only cost you the low price of $1,650. Right. I got this from different companies. Like I said, it looks official. It looks like a government issued this document, but I talked to my attorney about it. He said, no, that's bogus. It's just people trying to scam you out of your money. So just know that once you get your trademark, other than what you said, 5 years later, you have to submit the declaration. I mean, that's not a necessary thing.
That's right. These letters that you're getting are very common. In fact, the trademark office now puts a 1-pager in your certificate when they deliver them to you, indicating that you're going to be getting those types of things. So just beware of the scammers. And Jay, you're pretty good if it only the request was only for $1,600. I've got a number of federal registrations myself that I hold, and they're usually between $1,600 and $3,500, and they sound official. And it's like the Institute for International Protection of Proprietary Rights, with a really fancy-looking seal.
Wow.
International Catalog of Trademarks 2014. Yes. And this is like an international address. I couldn't even tell you what country this is in. So
it's in a bank in Switzerland.
Exactly.
Happy to take your money.
Send it to us in unmarked bills.
Yeah. We can talk a little bit about registrability on the next slide, but I just wanted to mention something here called tests for infringement. Registrability, like I said, is the ability to get that trademark registered. Once it is registered and you have to enforce it, what you're looking for is called the likelihood of confusion. Would this theoretical person, if they approach a shelf, let's say at a drugstore, and they go to a certain department, they see your goods there, and they see somebody else's goods, would they be confused by the similarity of the terms, maybe the logo, maybe the color? It's that likelihood of confusion. And that's really getting to the gist of it, because somebody who's trying to infringe your trademark, or trying to not infringe, I guess, but failing, they're trying to deceive the public. They're really trying to say, I mean, if you were to go to, here in Atlanta, we have a lot of CVS drugstores. If you were to go to the CVS drugstore looking for a painkiller and you went to the shelf that had Tylenol, it's usually in a nice red box. If somebody, that's the way I find it. I go down the aisle and I scan and I look for red boxes and I know I'm going to find Tylenol. If someone else comes up with something with a similar name, Litanol or something like that, and puts it in a red box with a similar font and maybe some lineage on it that's similar, they're trying to deceive the public. So that would be likelihood of confusion. You then would have the ability to sue them for damages for infringing your trademark.
Okay.
I put something else down here called dilution. That doesn't happen in many cases. That's when you have what I call a super trademark, a trademark on steroids. That's when you develop a whole family of marks. And it's more than just the one-off usage of marks. So when you have a family of marks, let's say somebody like a McDonald's, then if you want to say Mick this or Mick that, you might get broader protection, let's say on something called a Mick watch. I'm just speculating. That's a wild one. Just made that up. That would be the kind of protection you might be able to get from a court, because the court would be saying, okay, McDonald's, you've spent so many years, so many dollars, protecting this mark of yours, and it's not fair that somebody can come in and say Mick watch. So let's go to the next slide, and I'll spend some time on some other concepts. One thing I wanted to just touch on briefly is the concept of registrability and selection of trademarks. The absolute best trademark for you to register and to go through without any question would be something purely fanciful, arbitrary, unique. Examples would be words like Kodak, Xerox, Clorox, Exxon, Polaroid. They're just weird names. I tell my clients, if you landed here from Mars and you saw these words, you had no idea what they meant. So those are good trademarks because they're unique. The downside is it costs you millions of dollars to establish this brand recognition. Let's go fast forward to the other end of the spectrum. You cannot get a trademark on something that's generic. Okay, car for an automobile. That just won't work. If you work your way up the scale towards the fanciful and arbitrary, something called merely descriptive, that's going to be a tough one. And I'll give you a specific example here in just a minute. The best trademarks that most people choose, and it does take, you got to be careful, and you might get a rejection that you have to fight, something called suggestive. And I think when you hear it, you'll know what I'm talking about. Suggestive marks sort of hint at the qualities of the goods, but they don't really spell it out. So copper tone is a really widely used example of a suggestive trademark. So unless you knew that that was for suntan lotion, you may not have known what copper tone was all about. It was at the back end of a frying pan. You really wouldn't know until you heard it. And what I tell my clients is if you can get somebody to have that aha moment where they say, copper tone, that's cool. I like that for suntan lotion. And they sort of pat themselves on the back and say, I'm smart. I figured that out. I had that aha moment. And I remember it. You've had a dramatic effect on that person. They're very likely to remember your trademark. So Staples is a good trademark for office supplies. We all know what it is now, but out in the middle of nowhere, it wouldn't mean anything. Explorer for a Ford vehicle.
You know what I love, if I may, I love when you talk about this. To me, it's very interesting because when I think about trademarks, I'm thinking very much about legal protection, but you're really kind of talking about this combination of marketing and like what you're excited about naming your business and how you can protect that moment of excitement and create a name that causes that excitement, and then that's worth trademarking.
Absolutely. Yeah. I've had experiences with clients where when they first mention their trademark, and if I smile, I know they've got something that's good. So then we try to find a way to protect it in the best way we can. And one of the things I do is look at what other people have done, see what the risks are, and try to come up with a really smart way of filing it by describing it in a way where you're using it on just the right category of goods or services where you're not trying to claim the world. So be sort of specific as to what you're going to use it on, because you're going to have to swear in an affidavit or declaration that you are actually using it in interstate commerce on those goods or services. So that's a pitfall that I find a lot of even attorneys make when they try to, if they're low on divorce work, maybe they'll go ahead and try to do trademark work for a few weeks. And they try to claim the world in a trademark. Not good, because you can't claim you're using something when you're not in fact using it. It's fraud. So you'll get bounced out by the trademark office. So those are my thoughts on choosing a trademark. So arbitrary is the best, but man, it's expensive to get the brand recognition. Suggestive is probably where most people end up. Descriptive is not good, but it can work, and generic never works. Let me give you a specific example on two of the trademarks that I own. I formed a trade association. It's in Georgia. We called it the Georgia Automotive Manufacturers Association. Yeah, that sounds pretty descriptive, doesn't it? Guess what it is? It's Georgia Automotive Manufacturers Association, people who are involved in automotive manufacturing. I also filed a trademark on GAMA, G-A-M-A, just the words. So I filed both of them at the same time. I get an office action, which is the name of the document that comes back at you from the trademark office, saying that GAMA sounds pretty good, and they were ready to approve it. I think we may have to go back and forth on a couple little tweaks, but GAMA went through pretty well. It was somewhat arbitrary, and it was a new word, that new sort of coined word that no one was using before for automobile trade associations. Georgia Automotive Manufacturers rejected because it was descriptive. It was, but the way I got around that is there's something called the supplemental register, where it's sort of a secondary register at the trademark office. There's the principal register and the supplemental register, where descriptive trademarks can go for about 5 years. And during that 5-year period, if they develop secondary meaning, they can then be elevated to the principal register where they get more rights. So that's what I did. I transferred my filing from the principal register to the supplemental register and got the words Georgia Automotive Manufacturers Association approved.
Okay.
Yeah, so it's sort of my own story on that one for you.
Cool.
Yeah, let's go to the next slide. I think we'll be transitioning here. How are we doing on time?
It is about 9:25 right now.
Okay, let me spend a little time on copyrights. I want to make sure we open up the floor for everybody to ask some good questions as well, and the three of you to ask questions as well. So copyrights are really a different concept. We're not talking about brands. We're talking about protecting a manner of expression. So let's go to the next slide, if you would. The circle C, that's the good news here, is the circle C is both the common law and the federal registration symbol. It's also widely known internationally as well as the word copyright, C-O-P-Y-R-I-G-H-T, as well as its foreign translations. But if you put a circle C on something, I think most people will know you're claiming a copyright on it. Now, typically you can get a copyright on books, software, pictures, musical recordings. One of the examples I give my clients is, let's say you go up to this beautiful waterfall in northern Georgia and you take a picture of it. You may be able to get a copyright on your picture. Well, if there's somebody standing just down the stream from you and they're doing a watercolor of that same waterfall, they can get a copyright on that. Somebody else down the way doing a pastel, they can get a copyright on that. Somebody else down the way doing a charcoal of it. Oil painting, it's the same subject matter, but a different manner of expression. Totally different concept than a patent, where a patent is unique on a certain specific thing. A copyright protects you on the manner of expressing the waterfall, for example. It does have a definite term. Terms get a little complicated, but just as a rough rule of thumb, it's the life of the author plus about 70 years. So they can run for a long time. And that's one of the reasons that you're really going to be careful when you go out there on the internet. And like I said before, just because it's on the internet doesn't mean that it's public domain.
Right.
It means you got to really be careful because, and I'll tell you another story in just a few minutes. We'll get a personal war story on this one. Anyway, so let's say you come up with a new product and you come up with a clever trademark. So let's put a TM on it, on the words. And if you come up with a clever logo, let's put a TM on the logo. And then let's say you have a flyer that you develop describing this product, and you develop this beautiful website. Well, on the flyer and on the website, I'd be sure you put a copyright notice. And the copyright notice, you'll find it on the Copyright Office information. And the Copyright Office does have some really good information available to the public. I think one of the booklets is called General Information Regarding Copyrights or Copyright Basics. It's got to sound something like that. Put your copyright notice on there, and it's a claim to the world that you're holding that out as having original work in it. Why don't we go to the next page, next slide. So I spent a little time on some of these, but sculpture, motion picture, sound recordings, all of these things can be covered.
And like song lyrics would be in there too, right? Because I know a lot of people try to make T-shirts and stuff from song lyrics.
Yeah. So with the song, you can have a copyright on the music. You can have a copyright on the words. Think of the words as sort of like poetry, and you can get a copyright on poems. Next time you go to an antique store and you pick up a CD, you guys remember what those are? You'll see there's a circle C on the CD, and there's also a circle P. A circle P is for the sound recording. So that is basically protecting all the hard work that RCA or Sony did to develop that sound recording. So you have copyrights on the music, on the words, and you've got a P on the sound recording. Let's go to the next slide. So as with trademarks, you have both common law and federal registrations. Common law is simple, and it's free. It's the circle C. You got to put the year. You got to put the name of the owner. And a few other things that you need to add to that. The federal registration is something that the copyright application is about as easy an application as they get. A trademark application, on the other hand, can be a little complex. And Jay, you may know that. You got to know some of the language and the procedure to do a trademark application right. And I'm not trying to sell legal services, but you do.
I recommend it. I used an attorney that came highly recommended. So yeah, it is a little complex, and it's nice to have somebody walk you through the process, at least for the first time.
Exactly. Now, a copyright application, I tell my clients, I really don't want you to pay me for the application because it really is just a fill in your name, address, type of goods. It is a true application. It's maybe 2 pages long or so. The only tricky part is whether or not it's a work made for hire. In most cases, it's not going to be. But let's say you hired somebody to design your logo. Then you may have a work made for hire question there. I mean, who owns that trademark or copyright rather? So the question is, did you get that covered when you retained that logo designer? So you want to make sure that you own it. And that gives you the right to get the copyright on it.
Or in my case, the logo company goes out of business, so I don't have to worry about it.
Right. So I told you I was going to talk about both registrability and infringement. So trademarks, we hit on that a little bit. Same thing with copyrights, okay? You might be able to get the registration. That usually goes through fairly easily. They may ask you to tweak a word or two in your description. If you've admitted you're basing it on a prior work, they may want to know the difference between your 2 prior works. But that usually goes through, and then you get a nice certificate. It's not as fancy as a trademark certificate, Jay, I'm sorry to say. But you do get that. It's a really long combination of words and numbers. So you'll know it when you see it. But you got to be careful with infringement. Again, just because you get a copyright registration doesn't mean that you can use your copyright without being accused of infringing somebody else's copyright. And even before that, before you start using something, you need to investigate whether or not you might be infringing. So in both cases, you want to do a search. So this applies to both trademarks and copyrights. Be smart. Search what's out there. On trademarks, the Trademark Office has a way of searching their database. The Trademark Office database is limited to actual registered marks and pending marks, as well as marks that have died. They actually use the word dead, I think, on the Trademark Office site. So you'll find those, but it's not going to, a Trademark Office search will not give you access to common law trademarks. I mean, you can search and search all day, all night on the internet, try to find those. If I have a client that's going to invest a lot of money in goods or services, I typically recommend a computerized database search. Unfortunately, those cost, I'm going to say, I can't quote their fees, but let's say somewhere in the range of $2,500 and up. It's very expensive, and what you get back is a pretty thick booklet that's going to take you hours and hours to go through with every federal registration, pending trademark, dead trademark, common law trademarks that they can find on the internet and catalogs and everything else. They've got some very sophisticated computer databases that'll take, let's say you come up with a new word, they'll parse that word, they'll split it into its roots, they'll translate it into Latin, French, and German and look for all possible ways that you could possibly get in trouble. Good news is you'll learn a lot. The bad news is you got a lot to work your way through to make sure you're not infringing.
But that's only a thing you need to really think about if you're investing. Like if you're Coca-Cola and you're like, okay, we're going to do a $10 gazillion marketing campaign, then you want to make sure. But if you're like launching your $500 private label product on Amazon, maybe it's not quite as important.
Right, and that really boils down to you're never going to be able to do a perfect search. And even if you get an expensive search back from your lawyer, he's going to have some words in there that say, you know, this is the best we could do, but there's always risk. The databases may not be complete. We may have missed something. We may have misconstrued the goods or services. There'll be some outs, if you will. So you're never going to get 100% assurance. You have to tolerate the risk. So if your investment is low, I think you can have a little higher risk tolerance. You're never going to get 100% insurance policy that you're not potentially infringing. So, you know, just be smart about it and just go out and, you know, search the web yourself and take that trademark that you're using and split it up into different words. Put a hyphen in it. Figure out how somebody else might try to use it. See if you can find something that's close. Do a search on Twitter. Do a search on Facebook. Do whatever you can to try to protect yourself. Because the last thing you want to do is go into something and be accused of willful infringement, which means that you knew it and you did it anyway. So courts don't like that. So let me tell you the story about my local bar association. We were working on a website, and our graphic designer came up with a logo for us, and he put it on Scales of Justice. And we got a letter, the Bar Association, from Getty Images. Now, a lot of you are probably familiar with Getty Images, and it was a cease and desist letter. And the damages, let me just say that they were alleging, were probably in the range of 5 figures. Well, I was the patent, trademark, copyright attorney on the board at the time, so they said, Rick, there you go. It's your job. So I started to communicate with them. Told them we're a non-profit organization. And I even was able to negotiate the amount down to 4 figures. But even then, that was more than the dues we collect in a whole year. So Getty and others like them have very sophisticated search technology that some people call them spiders. They just crawl the web when we're all sleeping, looking for logos and words that infringe.
That's how they found us, Cordelia, when we used the barrel of monkeys from Hasbro, and Hasbro came after us with a cease and desist letter. You can't put that on your T-shirt. It's like, who told you?
I think that a lot of times, from what I've heard, this is totally non-legal, anecdotal, but usually you get a cease and desist, and it means you have to stop. It doesn't mean you owe a bunch of money, but you actually got, your bar association, Rick, actually got like a bill, right? Like, don't just stop using that image, but give us a bunch of money too, which I think is kind of less common, but I don't know, maybe I'm wrong about that.
It is, you're right, it is less common, but it is common with companies that enforce music rights, publishing rights. They'll usually come after you with a specific level of damages. And
you used Napster earlier too. I saw that you had the Napster logo on that one slide, which is like, that was a very dear friend of mine back in the day. I would spend hours and hours after, it's like till the wee hours of the morning ripping and burning music. And it's like, they of course got in all kinds of trouble.
Right.
But
I've worked with clients, let's say, who were college students, and they just downloaded a ton of music. And I mean, their download capability was off the charts by a couple of orders of magnitude compared to the guy in the dorm room down the hall. Well, they were the ones that would get the letter. And I mean, the downloads are easily provable, not only on their equipment, but also on the bandwidth they were using at the dormitory. It would spike it right off. So we were able to negotiate those down, but usually there's a payment. And the music companies, Getty, they will not let you off. Usually they'll ask you to, to pay something. Fortunately, I was able to negotiate something with Getty where they're not letting us off the hook ever. They're holding this letter over us forever, so we don't use the scales of justice anymore. We have not had to pay them anything, but I bet you if we put those scales of justice up there right away, they'll come after us.
Now, what if you then went and hired an artist to then draw you a picture of the scales of justice? Could you use that, or would that be, what did you call that before when you copy somebody's idea, like confusion?
That's really the trademark concept of likelihood of confusion.
Oh, okay.
Copyright. With copyrights, it's more of a one-to-one correspondence. I mean, is it the same or is it a derivative work? So, I mean, if you were to just totally independently come up with scales of justice, that's one thing. But if someone would look at your trademark and the let's say general parameters of the scale were about the same, the same height, the same proportions, the two scales about the same width, with the same chains, made in the same color, it looked like it was derived, then you're probably guilty of copyright infringement because derivative works are really dangerous.
Okay.
I don't want to go there. So
this might be a good segue into talking about Amazon merch, by the way, because that's, a lot of the stuff that's on there. And Rick, I don't know if you've had an opportunity to look in Amazon merch where there's hundreds and probably thousands and thousands. And Chris is the Chris Green who is in the chat room is the master of all things merch. Okay. But there's a lot of things that are derivatives of other things that I'm sure have all kinds of copyrights or trademarks and.
Right.
Actually, this might even be Cordelia.
We actually have a
we can go into some questions because we have like 12 questions.
Yeah. Well, I don't know. I just wanted to give Rick the chance to finish his sentence if he wanted to. I don't know if you were done with your thought or whatever, and then we definitely have 5 million questions.
Yeah. Just want you to be left with the concept of, one, there's a difference between registrability and infringement. If you're going to start using something and you think it's new, please do a search on it just to be sure you're okay that trademark is available to you and you're not walking in and infringing somebody else's trademark. There are ways you can get somewhat comfortable. You can spend the $2,500 to whatever thousands of dollars to get very, very comfortable, but you may not have to do that if your investment is low. So let's say you're going to have $300 worth of investment. I mean, are you going to want to spend $2,500 just to make sure you're totally comfortable? Your choice, but most entrepreneurs would not. For copyrights, usually you're going to know it when you see it. I mean, why are you using that slogan? Why are you using that particular font, for example? And Cordelia was telling me about some things related to Star Wars. May the 4th be with you, and things like that. It's just...
yeah, I saw this shirt in my Facebook feed, and I grabbed it for the show because I'm pretty sure this is a bad idea. Right? I mean, Disney's going to come after these people, or are they going to, hopefully make, maybe their hope is to sell 1,000 shirts today and take it down tomorrow and be done with it.
That's it. Yeah.
There it is. So you guys can see, wait, did I shared the wrong, sorry, I shared the wrong.
There's also this.
We saw it.
You saw it.
Yeah, it's just a smaller
Star Wars thing, and then I had another one here.
May the 4th be with you. Yeah.
Now this one I was curious about because I don't know if you're a Doctor Who fan, anyone. This is a total reference to Doctor Who.
Yes. But
the police box is just a thing that was used in England also, besides being part of Doctor Who. And this just talks about a box being bigger on the inside than the outside. So I was kind of curious, and I don't know if you want to get into this now, but is this legit? Or could you do this even though everybody knows this is about Doctor Who? Or is this copyright or trademark or whatever infringement?
Yeah, I guess my first reaction to that is the box. Does that really look like the Doctor Who box?
TARDIS.
If so, are you trying to profit from all the money and effort that they put into establishing Doctor Who?
Yes. I mean, I assume the people who made this shirt are trying to profit off of it.
Yeah, so the question would be is that box a logo that they've got a trademark on? So I'd be a little careful on this, and I don't want to sound make you totally paranoid or worried about everything, but one quick solution to a lot of this is ask for permission. I represent a lot of professional photographers. They always ask for permission. They take photographs of people, they ask for permission. They take photographs of public buildings, they ask for permission. It's easy to do. I'm also a musician. I did a score for some Beatles tunes. I asked for permission, and I sent them my score on that. It's really simple to do. And they said, who are you performing it for? Oh, it's a local symphony orchestra. How many people are going to be there? Oh, 40 or 50. Are they going to pay anything? Yeah, $3 a head. And they said, have a nice life. Go ahead. They knew we were not going to threaten them. A good rule of thumb is.
Now, what if, let's take your example though. What if somebody was in the audience of your composition,
Yes.
and they filmed it with their phone, and then it went viral, and like you ended up making $1 million because people watched your video and bought ads off YouTube from watching your video. And so you ended up with your initial intention of it being for those 40 people, but then it went viral.
Yeah. Excellent question. And those are exactly the kind of cases that make really bad case court for the people. Now, I can tell you the way that one would have probably started out. I would have gotten permission from the people holding the copyrights for the Beatles music, saying, I have this limited license for one performance on Sunday, August, whatever, and no recording is allowed. Okay, that's probably what it would have said.
Okay.
So then the question is, what about the person out there who's recording it? So what I probably would have done is put in the program that no recording is allowed. So I could then have a defense myself. But that's the kind of stuff that makes lawsuits.
Okay.
What else should I have done to police that? Should I have ushers out there, looking for people with, it's like if you've ever been to a Verizon amphitheater, there are the ushers go up and down the aisles sometimes looking for people who are, recording when they shouldn't be. Yeah.
Okay, so let's talk a little bit about merch. We do have a question here from Chris. Are politicians really fair game? Can you really put Trump's likeness or Trump's just anything about somebody's political ticket? Is that legit, or how does that work?
That gets a little complicated because it's sometimes it's called parody.
Yeah, somebody asked a question about parody.
Sometimes it might be called fair use.
There's a lot of parody T-shirts.
Mm-hmm. Yeah, that's a tough
one. We have to hire you to get your opinion on that
one. Even if you paid me to give you a multi-$1,000 opinion, you may not like it.
You're going to get a lot of it. Depends, I think.
Yeah. So let's look at the parody. Would that be the kind of thing that you'd be willing to go to the public figure and get permission on? They might like it. Some celebrities have told me, and these are people who are Hollywood type celebrities. I mean, wrestlers, movie stars, they say any publicity, even bad publicity, is good publicity. So is a parody bad or good? I mean, would the candidate approve it? Yeah, that's probably worth thinking of before you publish that. And just, again, follow the money. This is the test I was trying to get to before. If the owner of those intellectual property rights, the trademark or the copyright, is going to be losing a lot of money because of what you've done using what they're claiming is their property, they may find a way to come after you. And then it's going to cost you money to find out or to prove that you're not guilty, or you don't have to pay damages and things like that. I can be pretty aggressive as an attorney, but on the other hand, it's sometimes a lot easier to start out by asking for permission first, see if that doesn't work, and then you can drill down on allowable parodies. And there's some case law that you can find some comfort in there. But again, Jay and I were joking about this. It does depend. And you're going to know it when you see it. And you don't want to be, obscene or anything like that. Be tasteful. Anyway, sorry I can't give you a definitive answer.
So what about if somebody says something like in a speech or in a comedian's routine, but it's not necessarily like a book or a song that's kind of recorded. Like, is that like jokes or something that people do T-shirts about all the time too? Like some comedian will do a joke, and I've seen there was one comedian that did a joke.
Yes.
That then spurred this whole website where people did the thing that he joked about. They sent you a bag of this particular body part in gummy form. So he did a joke about a bag of body parts, and I'm not going to name the body part.
Yeah.
right? And then somebody did a website about the bag of body parts and they sent them to you, and it was like they were gummy candy, right? So this person was profiting off this comedian's joke, and he had a website domain, and people went, and as a gag they sent everybody a bag of these gummy candies. So what is that? Seems like it's stealing to me.
Yeah, to me that'd be very risky. So let's just look at some of the possible ways that the comedian could allege he's got some rights here. I mean, he could allege he's got a copyright in his routine, in his jokes. He could file his script, if you will, as a copyright. And you can do that even within 3 months after publication. So, I mean, he could file that and then go after even statutory damages, in copyright cases are not so bad. I mean, those run from like $750 to, $100,000 or something like that. The fact that they're trying to profit off of something that they really know is owned by somebody else is the thing that it just doesn't sound right. And you have to be a little smart when you think you might end up in court, in front of a judge or a jury, because they're going to know why you did this. And if you're trying to profit on somebody else's, intellectual property, they're not going to like that either. There's another body of law. There's and it sort of falls under trademark law. It's called unfair competition. And that's where you can do things that sort of fall through the cracks a little bit. So it's not something you necessarily file for a trademark registration on, but it's more unfairly competing using a variety of things to profit from somebody else's ideas. So if I were representing the comedian, I'd probably come up with a multi-level attack. Copyright infringement, unfair competition, maybe even a disparagement claim in there. Who knows? Maybe a libel or slander. We could come up with
it all in. It's like a cooking recipe. So let's talk a little bit. We have a large private labeling component in our audience as well. I don't know, Andy, if you wanted to ask any specific PL questions or if I should jump in there. Do you have anything on deck?
No, go ahead and shoot your questions and then I'll follow up.
All right. So one of the questions is, let's say that you see, I hear this all the time. People, they see a product on Amazon, whatever it is, it's a wooden spoon. And so then they say, well, I'm going to do that exact same wooden spoon from China or garlic press, and I'm going to call it Cordelia's wooden spoon. And they have not innovated or changed the design at all. They're simply private labeling it as their own design. People do that all the time. What's the deal with that? Is that okay? Like, how can you, if you wanted to do that wooden spoon, would you then go to the patent office and see if somebody held a patent on wooden spoons to make sure that you're not taking their patented idea? I don't know. What would you do?
Yeah, this is one where I'd probably, to be prudent, and this is what you want to do before you start investing in private labeling. And I think there's a little more cost in that than just doing T-shirts, for example.
Right.
So they have to think about things like, is that wooden spoon unique enough that it could be patented? So you may want to do a patent search. The key words here now are going to be searching. So lawyers sometimes call it due diligence. It means being smart before you embark upon this decision. So you may want to do a search on patents to see whether or not.
Would you just do that at the Patent and Trademark Office at the government website?
Yeah, a couple of ways you can do that. The Patent Office has a search site. You put in words and you can get pretty clever with Boolean logic and things like that. Google also has a good search capability. I use both typically, but I also use pretty sophisticated databases that I have to pay a subscription to do the higher level searching on concepts. And sometimes you want to use better sophisticated, searching capability for photos and things like that.
Okay.
So possibly patented. You may not have to worry about a trademark on that wooden spoon if there's nothing on it, if it's just a generic spoon. But what if it's being made by somebody else in China with a similar name? What if it's being sold by somebody else here in the U.S. that has come up with a name for it, and you don't want to walk into a trap where they've already gotten a trademark on that. And even if they have not registered it and they're using it on a common law basis, they may have some rights because they have first use of that trademark. So remember I used the concept of footprint?
Mm-hmm.
They would have rights that could even precede yours if you filed for a federal trademark application, if they had a first use. So you just want to be smart on that. And then a copyright. You could also get a design patent. Let me back up just a little bit on the shape of that spoon. If the shape of the spoon is so unique that it has ornamental qualities, and for a design patent, they can't be functional. They have to be ornamental designs, like the shape of a perfume bottle would be a good example of a design patent. It has nothing to do with holding the liquid, but it's just a really cool shape.
So it sounds like actually what a lot of people do is kind of okay, which is you look and you see, all right, there's 6 other people making the same exact wooden spoon. So probably, I'll do a little search and just see if wooden spoon comes up as being a unique product. And if not, I'm probably okay to copy it.
Yeah, there's risk. There'll always be risk. But so do a search on the patents. Do a search. Hey, if you find a competing product, take a look at the packaging on it. See if they've got a patent number on it, or a TM or a Circle R or a Circle C for the copyright on the packaging or something like that. So look at the patents, trademarks, copyright issues. And if you're buying things overseas, I'm not sure you'll have a product liability issue with a wooden spoon, but you could, for products like that. Something that's maybe a mechanical, there can be product liability issues. There can also be product recall issues. I mean, when you get into the private labeling. But I'm here to talk about the intellectual property side.
So, Rick, let me just give you an example, and this is this is a situation I think a lot of Amazon sellers that do private label find themselves in.
Okay.
So I had a product I had been selling for about 7 months and selling really well. Probably had sold I'd profited over $100,000 just on this one product.
Yes.
Received a letter from a lawyer through my Amazon account, which you're not supposed to do, from another seller, but it was the other seller's lawyer, asking me to immediately take my listing down and claiming that I was infringing upon their patent. Okay. And so I got my patent lawyer. He looked at it. Well, their patent was actually pending, and they had actually been denied 2 times. So they were on their 3rd try, and it had been about a 4-year process. Yes. Of them applying. And my lawyer found actually all the way back to the 1900s, there had been patents with this product, but this person was claiming that they had changed the product a little bit, right, in their patent, and I guess that's why I was denied the 2 times. Right. However, my lawyer told me, Andy, it is dangerous because it's kind of like a game. And so, she's paying a high price law firm just to keep, putting that in the process. And he said, if that gets approved, if one of those claims gets approved, she can come back and sue you for 3 times your profit. So basically she could have sued me for $300,000, at that time. Right. The tricky part though was the patent was worded in a weird way. Like I would have never been able to find that patent because it really had nothing to do with the product. You know what I mean? So I don't know if you could talk about that at all. Like there is, it is kind of tricky to find those patents sometimes.
Yeah, you raise a really good point, Andy. Patents sometimes are worded in very weird ways. One of the things about the way patent attorneys get to work is we can be, and the inventors be our own lexicographer. We can actually make up words. So try to
lexicographer. No, I know it's a real word.
Try to search words that aren't out there in the public domain, right? But you must, I think you had a good lawyer, because the first thing you do is if you do get a cease and desist, you want to find out what are the rights they're asserting against you. So you would have asked, okay, show me the patent. Well, they didn't have a patent, so they had a patent application. The fact that it's been pending for 4 years that doesn't really make it that bad, because most patents, after you apply for a patent, they're usually hanging around for 3 to 4 to 5 years before they get issued. But the fact that they're into 4 years and they've been rejected twice means they're maybe honing in on something that they might be getting some patentable claims on. So what your attorney probably should have done for you is look at the potential patentable claims, ask their attorney, what are the claims you're going to assert against me? And then on the offense side, do your own prior art search. And it sounds as though he was already starting to do that by saying, look, somebody has a patent on my particular device from 50 years ago. Someone cannot get a patent on a prior art device. It just should not happen. It doesn't mean that it might not happen. So let's say the patent office doesn't come across that prior art device that your attorney finds out about, and they get a patent, and they assert that patent against you. A patent's presumed valid when it issues by statute. You're then going to have to prove that it's not valid and that it's not infringed, which gets expensive.
Yeah, I mean, my lawyer was saying it would be like a federal lawsuit. The minimum, he said, would be $50,000 just to defend myself, and it'll probably go up to 100. And then if they win, I'm paying 300. So you know what I did? I did what you just said earlier. I contacted the owner. I called her like 4 times. And I just said, hey, look, I want to work this out, whatever you want me to do. Her first words were, you know what? I'm sorry. My lawyer shouldn't have sent you that letter. We sent it out to multiple sellers on Amazon, but I don't feel that your product is infringing on my patent. Unfortunately, that was after I paid my lawyer $3,000.
I was going to say, sounded like your lawyer is one of my partners in terms of quoting those. It does get expensive. It does get expensive to defend a suit. But you did a brilliant thing. You need to contact the owner. Your lawyer may not like it, or your lawyer may.
He didn't like it at all.
Don't admit anything, and be smart when you talk, and keep good notes and stuff like that. But that's really the way a lot of this gets settled out, because it's going to cost her money too,
right?
To bring that lawsuit. I doubt if there's such a skimpy little patent that might be issuing, I doubt if their lawyers are going to take that case on a contingent basis.
Right.
It sounds as though she's just trying to defend potential market share.
Right.
So she's probably paying her lawyers too. So at some point, there's a couple of lines on graphs that, you're paying fees, they're paying fees, and eventually those lines cross at the ultimate pain point. So you want to bring that pain point down real low. And if she was smart, she probably saw what you were doing and said, I'm not going to lose any money because of what you're doing. And that's really the ultimate test. Is she going to lose money because of what you're doing? If you're right in her wheelhouse and she's going to lose money, she'll find a way to come after you.
Okay.
Well, and one thing I love to advise clients on is cross-licensing. So let's say you then file the patent on yours, and you're going to get a patent, and they have a patent they're asserting. Why? Oh man, bar associations will hate me for saying this. Don't let the lawyers, charge a lot of fees just to have their day in court.
Right.
There's smart ways to get these things settled very fast. I mean, contact the other parties. Be smart about it, okay? Because there are a lot of snakes out there. But if you're a savvy businessman, go in, set the agenda for the call in advance, and be prepared with some facts. Have a photograph of your device. Maybe have a copy of the patent claim that your lawyer says they're about to get issued, and you can say, hey, my device does not have a lever right where your patent claim says there has to be a lever. So therefore, I don't infringe. And oh, by the way, here's a patent that I found from 1931 that shows my device with no lever, so I'm free to make it. Now what do you want to do? Got ya.
But bottom line is kind of, I think what you said too, if a company's big enough and they, if there's money involved, that's when they're really going to go after you, right?
You're right, Andy. Yeah.
Until you kind of have to make, sometimes it's just more of a pragmatic decision.
Yes.
It's maybe not the perfect world, but it's like, it's better for me to spend my money in a new private label product than fight this battle. I'm just going to let her have it and move on. So
Andy, you're not still selling this then, right?
No, I am.
Right. Oh, you are?
Okay.
Yeah, absolutely, I am.
So it had a happy ending then, other than the $3,000 out of the $100,000 that you made.
But you know what? Yeah, I regret not trying to contact her first before contacting my lawyer. Because again, she's a third-party Amazon seller too, and so she's not like this big corporation. You know, she knows what I do. I know what she does, and I should have kind of went that way first. You know, it's not like, who are you dealing with, Hasbro? It's like, it's like me calling you, Jay.
Right. Exactly.
All right, Rick, can I ask you, we're a little after 10 here. Do you mind staying and answering a few more questions, or do we need to wrap up?
How about a couple more questions?
We've got like 16 questions in the chat room, and I think a few of them can be combined. You know, a lot of people are asking, I mean, a lot of this is geared towards merch, towards T-shirts, because that's the new hot thing now for people to basically sell an idea and get royalties on that idea. It doesn't cost them any extra word, and it's just passive income at its finest. So, a lot of these questions are geared towards, just to give you a couple here, there are a lot of defaming products against Obama. Some are pretty obscene. Is there risk in selling these? You can combine that with, can anyone use Hillary or Trump's name on a shirt with an opinion about them? It doesn't, I don't think this goes towards like the likeness, but it's just like, here's my opinion. Isn't that freedom of speech? So what supersedes what when you're talking about that type of thing? It's like, my opinion on Trump is he's a jerk, and I want to put this on a shirt, and, can I get in trouble for this? What are your thoughts on that?
Yeah. Here's the answer. It depends.
Not on whether or not Trump's a jerk, but.
But let's start out this way. So if it's a totally independent statement that you put on there, you're probably tending towards being pretty safe. Okay. Now, if you're starting to defame somebody, are you getting into the libel and slander territory? Well, then they're a politician, so they're a public figure. So maybe, you have more rights there to do that. I hate to say that, it just gets really gray. And that's the whole issue with politics. So start out by thinking permission. Is there a way to get permission for what you're doing? Or is it so outrageous?
No way, no how.
No way.
Just think about it. Like, if somebody's putting I don't know, I guess it's all subjective whether what's considered defamatory. Right. How do you pronounce that?
Defamatory. Yeah.
Defamatory. Thank you. But if somebody just, hey, Trump's got stupid wig on and he's a jerk, and you put a T-shirt out there, it doesn't have his likeness on it. It's just your opinion on him.
Right.
Can you get away with that?
You're gonna hate this. It depends.
It probably depends if Trump cares, right?
It depends. Everybody have a beer.
Yeah. Well, let's just put it this way. It's really going to depend upon how bad it is, and whether or not so let's just talk in generalities here. Let's say it is so bad that it's outrageous, that it gets the Trump camp really mad at you. They can afford to sue you, to stop you. And do you want to have to pay a lawyer to stop? So it's how much risk do you want to take? So you can make up your own sentence that has no meaning at all, and you won't sell a single T-shirt. So let's start working your way up the risk curve. Okay?
Could you tell us, if somebody, let's say that Andy decides he wants to attack somebody else for infringing on his patent or trademark or copyright, what's the ballpark? Like, talk a little bit about legal fees for these various and sundry things. I know it depends, but can you give us the ballpark or no?
It's very expensive to assert a patent or trademark or even a copyright against a client. And part of that is because the federal court system, which is probably where you'd be for at least a patent or a trademark, it's expensive to file that complaint. The complaint has to be based on true facts that not only you, the plaintiff, are alleging, but that your lawyer has independently verified. So there's a burden on both the plaintiff and their counsel to make sure that this is a valid complaint. Because fast forward, let's say it's frivolous and you're just doing this to shake somebody up and to slow them down in the market. The court could come back if the defendant said this was a frivolous lawsuit and get damages, to use that word, against not only the plaintiff for frivolous litigation, but also the lawyer. They're called Rule 11 sanctions. And it happens. Happens a lot. And it's because the lawyer didn't do their homework.
So what if, so I feel like sometimes people send cease and desist letters from law firms just to scare people, and they really have no intention of actually pursuing any legal action at all. They're sort of, like you said, hoping to just knock them off the market from a little sort of scare tactics.
Right.
Can you hire a lawyer to write that letter? I mean, do lawyers do that?
You write cease and desist letters?
Yeah, and just like, we're not really going to sue them, but can you just write me an official sounding letter?
Well, let me break that concept up a little bit. So, let's say if what you want to do is just make them aware, and that would be a notice letter, just to say, hey, here's what we got, so let's talk. Okay, so sort of like what Andy was saying. That might be a good way to cross-license, get somebody to the table, but also make them aware of your patent. If you put a little more teeth in that letter and you cause what's called reasonable apprehension in their minds, then they could file a federal lawsuit against you to have that patent or trademark declared invalid. So as you work your way up the threat level of that potential defendant, you're taking on more risk that they're coming back at you and filing a lawsuit against you for a declaratory judgment that that patent or trademark is not worth the paper it's printed on. And by the way, you should not have sued me.
So if people are threatening us with cease and desist letters that are frankly just BS, we have legal recourse. That's what you're saying. You can say, this is freaking me out, and they don't have a legal leg to stand on, so they owe damages.
Yeah, we're going back now to you're the receiver of this.
Right. Sorry. Yeah.
If you're the receiver of this, I would take any cease and desist letter pretty seriously. Probably be good to have a lawyer as a friend, or maybe on some kind of a, let me just say this generally about lawyers. When you retain one, make sure you know what the fees are going to be up front. I mean, I do virtually all of my work on a flat fee basis, and that's because I don't like my clients to be surprised. I was a company lawyer for a lot of years, and I always asked my outside lawyers, how much is this going to cost me? Because I didn't want to get beat up by my CEO, okay? I was looking for survival too. So I always demand to know how much is this going to cost. Now the lawyer may say, okay, it's going to cost us, $1,000 to review this and give you the opinion. If you want us to do an email response, that'll cost you X more. A nasty gram letter back might cost you $2,000, and I'm just making these numbers up. It really depends how serious you want to get. But the numbers you gave, Andy, those are not out of line, because your lawyer would have had to investigate that patent, pulled the files from the Patent and Trademark Office, looked at it, and maybe even looked at some of the patents that were cited in the Patent Office against that invention.
How can you discern a real legitimate legal cease and desist letter from a bogus claim? It depends.
Yeah, it depends. If it's from a legitimate law firm.
So you could just look them up on the internet, really, to kind of get your start.
That's where I would start. So if it's coming from a big firm in, let's say, I don't know, St. Louis, Missouri, okay? And you look them up and they look legitimate, I would take it seriously and look at that partner and see if they do intellectual property law. Then I would take it doubly seriously. But if it's a lawyer from North Dakota who's really low on divorce work.
So my lawyer looked at the law firm that sent me the letter, and it was like a 600-member law firm, huge, right? And he said, Andy, and my lawyer he works out of his house, right? He said, Andy, if we try to fight them, it's like a battleship coming against us, and we're just holding on to a dinghy.
You have a good lawyer, Andy. You got to pick your fights.
Right.
And that's, it could be that company that sent out cease and desist letter just, they had this law firm under a retainer to do any enforcement, and the client never even got involved, which sounded like your case, because when she talked to the owner, she recognized that letter should never have gone out.
Yep.
What about first use claim? We had a question kind of tied into a bigger question about first use. Somebody received a cease and desist letter, and when they researched it, they saw that the person that had filed the cease and desist letter didn't actually have a trademark at all. There wasn't even a trademark pending, and they just said, well, we were the first ones, first use, so we automatically should have a trademark pending here.
Right. Yeah. If I were representing the client that received that cease and desist letter, I would ask for proof of their first use. So what you'd be asking for is proof of their common law trademark rights. You'd want to see when they started using it, where they started using it, how widely they've used it, and then see what their footprint, to use that word, is. And where it gets a little murky now is, the internet is everywhere. So you put a website up there and you can have a pretty big footprint. Case law is still a little murky on enforcing that, but I don't want to, one thing I tell my clients, you don't want to be the first case law breaking new ground on new technology. So be careful.
Right.
Yeah. But
that makes sense.
Ask them for proofs.
Yeah, I had to do that with Scanner Monkey. I had to show them screenshots, actual screenshots of the website with dates on there. If there was like a newsletter, there had to be a date on there. So it's like you can show when you first put the trademark in use, because up until then it was just the TM on there until I could put the circle R. And there was another good question. I thought this was a very good question, and I'm wondering this myself. Karen Holmes had asked about, what about generic brands like you see at Walgreens or CVS that say as compared to Tylenol Plus or some other more recognized brand.
Right. That's really not trademark or copyright law per se. That gets more into unfair competition law, and that even gets more into Federal Trade Commission type law. And I'm not an expert in that, but here's a good policy. Always tell the truth. Okay, so if you're going to say as compared to, my product relieves your soreness in your elbow, 33 times faster as tested by Johns Hopkins University, in 19 whatever, so whatever you can say. Just be factual, be honest, be truthful. Don't stretch the truth when you're saying it's compared to. And I'm not an expert on advertising law, but that's where that falls.
What if you did not a drug, but like a kitchen gadget? So OXO is a big brand, right? And they have their special padded hand, but then I guess you're getting into design. So what if you say, this can opener as compared to the OXO Good Grips can opener, because it's a good grips and arthritis friendly and whatever. Are you allowed to do that?
Yeah. I can't give you a...
No. Okay, it depends.
It depends.
Let me tell you what I would think about. Okay, first of all, is that an actual true statement? That as compared to OXO, it does the same thing. Now, does OXO have patents on it? Does OXO have trademarks on it? Do they have copyrights on it? Are you doing it in the same kind of packaging? What are you calling yours? So if you're OXO or something like that, just, your gut's going to tell you. The more you're trying to trade on their goodwill to make it look like, sound like, package like everything else, then you're getting into dangerous territory. But let's say your product it doesn't look at all like theirs, because maybe the handle is a different shape, but it still has the same function. It helps arthritis, people with arthritis. And maybe you have your own patent on it, and you've got your own trademark on it, your own copyright on it. That I would, not knowing more, that's a pretty strong case then. Just be careful with saying as compared to.
Can people hire you? Are you? We actually had a couple of questions. Like, I want Rick to do my work. So if somebody wanted to file a trademark, could you help them with that?
Of course.
Are you taking new clients?
Yes. Yeah.
Okay. And then the next question is, what's it going to cost me?
It depends.
I knew that was coming.
And this is something that I will extend the Scanner Monkey discount to anybody that says they were online tonight. I've got certain rates that I just charge because that's what the work has. It's fixed fees, but I will discount that to anybody that says they were online tonight.
Okay, very cool. Wow.
And that'll expire. There's operators standing by, right?
There you go.
And if
You're
you
behind that wall.
Where do I send my money? You even gonna have a cool Twitter handle, IP Geekmeister. I like that.
Well, hey, Rick, I just want to say thank you so much for coming on. I really appreciate you spending time with us. And my new phrase now when anyone asks me a question is going to be, it depends.
It depends.
All right.
Andy's going to start calling people right away. No lawyers, just call them immediately. Just shut it down before it even gets started. All right, so when I go out after the show and I develop my Get Her Done Larry the Cable Guy t-shirt, that's probably not a good idea, right? Is that what you're saying?
Unless you call the cable man in advance, Larry the Cable Man, and do it. He'd probably don't prejudge him. He's flattered.
He seems pretty laid back. He'd probably go with it.
And he may just say, okay, I can't let you use it, but give me a penny a piece. So what's wrong with that?
That's not a bad idea.
And I can't speak for him, okay? But here's what he's doing. He's protecting his intellectual property.
Yeah.
So put yourself in his shoes. He's probably just not going to want to give it away. But if he's aware of it and gives you permission and gets some kind of nominal royalty, I think it's win-win.
I'm going to make Slamazon t-shirts, I think.
So, all right, I just have one more question before we let you go. So you said get permission. How do you, let's say I wanted to use a Beatles lyric in my t-shirt, or David Bowie. Of course, everybody's doing David Bowie now, and Alan Rickman and all these people who have passed and whatever. Who do you ask? Okay.
You can go on public databases, and like with music, for example, there's firms that license that music. It's ASCAP, BMI, firms like that. They're music license holders. They're the ones that enforce it as well. So give them a call. They've got offices in New York. They've got offices in Nashville, for example. Give them a call. They're more than willing to help because they know there's potential royalties in it for them. And that's what I did when I did the Beatles arrangement for that local symphony orchestra. I just called ASCAP in New York, and I said, here's what I'm going to do. I want permission. And, it took me about 3 or 4 connections, but I finally got to the right person who just sent me a nice letter.
Okay.
But it takes some investigation, yeah.
Okay. Like anything else, you got to put a little legwork in and just kind of reach out there and try it out. Cool. Yeah. Well, thank you so much for coming on, Rick. I did put your contact information in the chat. We will also have it available in our group if anybody has a question about it, if they want to reach out to Rick. And I can certainly personally attest that Rick will not tell you that he's going to charge you $10,000 for a 5-minute phone call, but he will give you the straight up, answer, and it's like, okay, this is the risk, this is the chance you're taking, and if you decide to do it, go for it. So
we need to add Rick to our little tribe. Is he part of Scanner Monkey?
But I'm thinking about it.
He's thinking about it.
Okay, well, yeah. you may get over.
He's going to get like 5,000 PMs every 10 minutes.
You're already going to get 65 new clients tomorrow morning anyway. So.
Well, in addition to being an attorney, I'm also an entrepreneur. I've got several businesses that I've started, and I just got an award as the International Entrepreneur of the Year. From an
Congratulations!
Wow, good for you.
My brain actually thinks more like you guys. Okay, and I've got the arsenal and knowledge of the legal system that I can help you with. Okay, so I'm not looking to publish a law review article. I'm looking to help my clients.
Right. Cool. Well, thank you so much, Rick. Thanks, Andy.
Thanks a lot, Rick. We really appreciate it.
Thanks for having me. I enjoyed this very much.
Thanks for coming. And this has been a production of Scanner Monkey, which is the best group on the internet for people who sell online. It's the best $20 a month you'll ever spend. So please join scannermonkey.com. Andy is a member and has been since we've started.
And do not use the name Scanner Monkey without the express written consent of Jay Bain.
I have permission. Jay gave me permission. So.
And we have a show tomorrow too that we should probably talk about briefly. We've got the Scanner Monkey cruise coming up. Basically, we're all meeting up on Saturday and we're cruising out on Sunday. So the 23rd, everybody's going to be in Miami, and on the 24th, we set sail for a new adventure. And how do the Love Boat lyrics go? I can't remember. But anyway, so we're going to talk a little bit about what to expect from the cruise. We'll have John Grollo on with us. We'll have Alex Mutt on with us. They both help coordinate this.
Jay, how many people are going?
We're over 100 now.
Yeah.
If you include all family members, husband, wives, kids. So it's going to be a lot of fun. And just keep in mind, this is not like a big, networking convention on the ocean with like lots of speakers. And we're all unwinding after a good Q4, and it's just camaraderie and fun. Yeah, there'll be networking. There's always networking when all of us get together, but that's not the primary function of the Scanner Monkey cruise. So.
The answer will always be, it depends.
It depends. Yeah, and wherever you are, how many drinks you have in your hand, it all depends.
So if I make a T-shirt that says "It depends," do I need to ask your permission, Rick, to say that?
I think Kat Simpson may have the right to that one.
What if I told you I represent Procter & Gamble?
Yeah.
And they make the pens.
That's true. Oh, that's a great T-shirt. You could have it and then like some Depends papers underneath
I
it.
do not represent.
Perfect.
All right. Thank you guys so much. Next week, we have Monica Busby, who is a very successful online seller, and she teaches kids how to sell online. She has a e-com kids, and these kids and their families are making thousands of dollars a month and really impacting their lives in a very powerful way. So she's going to be our guest next week. And then the week after, there will be no show because we will be out on the ocean. And so
we'll send pictures, maybe a couple of videos of Andy shaving his back.
Tomorrow's show, I think, is at 3 p.m. Eastern time. Live, and then of course we'll have the recording on YouTube later for people who want to check it out who are going on the cruise. So
just so you know, Cordelia, I may have to do that one from my car. I'm driving back from Pearland. Okay. So hopefully my phone will work really well with Zoom. So
thanks everyone, and we'll see you guys all soon.
Thanks again, Rick.
Thank you, Rick.
Good night, everybody.
Thanks for having me.